Hi, folks. My name is Chris Ukins. I'm a professor at George Washington University Law School in Washington, D.C. I'm a professor in the government procurement law program there. And we're very happy to be running this, our second summer series. Last year, we did a series on federal bid protests. And this year, we're doing one on state bid protests, sort of a complement to what we did last year. This series on state bid protests is also part of a broader effort to reform the ABA Model Procurement Code, or MPC. We'll be talking about that as we go through today's session. Thank you very much for joining us. And the recording of this session is going to be available on the program page, which is a Public Procurement International, and will also be available on the GW Law School Public Procurement Government Procurement Law Program YouTube page. So the materials for this program are available on Public Procurement International, and I teach 5 courses at GW, and I teach them all online. These sessions are a rough facsimile to what we do in our online courses. So there are reading materials. We have obviously this live session, this video session, and we also have exercises. So we'll have a bid protest exercise next week. We've had also some background videos. Normally for our classes, we're doing a background video for every session. We only have a couple this time. We have a background video for the first session that's sponsored by the National Association of State Procurement Officials, NASPO, Procurement Officials, NASPO. And we also have a video for the session on Tuesday. That's a video that I prepared, and it's part of our normal state and local procurement seminar, the seminar that I teach, but we're going to make it available as part of the session for next week, the third session. In these webinar sessions, we don't use the Q&A function because we find that the Q&A function tends to get walled off. Instead, we use the chat. So please feel free to throw questions up into the chat, and I'll be responding to them. The other panelists are going to respond. We have a couple folks who are Dan Shaney and Mike Beavis, who are also participating in other sessions. They'll be available to answer your chats as well, and we'll try to give you as many resources as we can in responding to the chat questions. I want to emphasize that we have folks with us who are from a broad range of backgrounds. All the panelist statements are in their personal capacity. Now, GW plays a very essential role in the bar, in the government contracts bar, and it's kind of like an extended family. And I just wanted to, and it's a note of sadness, I wanted to point out that a very respected member of our community passed away last week, Carol Park Conroy. She got her BA from the University of Wisconsin. She got her JD from the GW Law School. She clerked for District Judge Joseph Waddy. I actually looked him up this afternoon. But for those of you who have interest in this, for children with disabilities, there's a major statute out there that guarantees their education. He wrote the constitutional decision that helped drive forward that statutory change. He was a civil rights lawyer, and Carol clerked for him. She was in private practice and in the Justice Department, as many of the lawyers in this community. That's a common career path. She was a judge in the Armed Services Board of Contract Appeals, and that's where she got to know my colleague, Steve Schooner. She's a former chair of the ABA Public Contract Law Section. The current chair of the ABA Public Contract Law Section, Jennifer Dower, will be joining our session next week, our third session on Tuesday. And after she retired from the ASPCA, Carol really became a leader in the United States in the use of alternative dispute resolution. Most importantly, she was a mentor and a friend to many of us in the bar. So wanted to note her passing, and it's a significant milestone for the bar. So if you're interested in looking at the session from last week, from earlier this week, from Tuesday, session 1, that's available on Public Procurement International. Again, it's also available on the GW Government Procurement Law YouTube page. And because it's July 14th, it's what we call Bastille Day, a special happy National Day to our French colleagues. As I said in the first session, apologies to our foreign colleagues. We have folks from 37 countries and from 34 states and territories all over the world registered for this program. For many of our foreign colleagues in Europe and in Africa and Asia, this is a really tough hour for them to join, and we really appreciate their joining us, and a special shout out to our French colleagues. So today we're going to be talking about how to avoid bid protests. So in the first session, we gave an introduction to bid protests. We had very interesting discussions about some of the statistics and some of the mechanics of protests around the country. Today, we're going to talk about how to avoid bid protests. And in doing that, we're going to be talking, we're going to be moving up through the guts of the system. We're going to talk about, Bill Kerr is going to be talking about how you can address issues that are predictable in the procurement process, how a procurement team can work effectively to try to control risk. Lydia Hoover is going to be talking about some of the problems that we've seen in Maryland and elsewhere. And in our discussion with Lydia, we're actually going to see some of the problems that are very common across the country and that, for example, the Model Procurement Code might address. Liz Levy is going to be talking about her experience and what some of the things she's seen. She's done a large number of bid protests around the states, talk about some of the common issues that she's seen. And Bob Metzger will be focusing on, when he joins us, Bob will be talking about how is it that we can improve the procurement process overall to reduce the risks of bid protests, for example, by creating common terms and conditions across the states. So the reading for today, we don't have a video, background video for today, but we do have a reading for today, which is chapter 6 from Bill's pending book. It's going to be out very soon. He gave us, very kindly lent us the chapter 6, the unedited version, which is on bid protests. So you can pre-order a copy of Bill's book. It's available on Amazon and other outlets. And chapter 6 is on the program page if you'd like to click through for that. And this is the beginning of the chapter. This is an unedited chapter on bid protests, and it really talks about the mechanics. He's going to be taking a snapshot from that chapter in our discussion today, but I really strongly encourage you to read the chapter. It's a very thoughtful approach to how procurement professionals can deal with issues that might result in a bid protest. Our next session on Tuesday is going to be a discussion of how we can have possible improvements of the bid protest system. I very much encourage you to join. That'll be the same time from 6 to 8 in the evening on Tuesday. And there's background materials you can take a look at beforehand. And then our fourth session, our last session, will be a week from today, on Thursday, on the 21st of July. And there we're going to have a mock bid protest. The mock bid protest is available on the website, Public Procurement International. And we're going to have a large number of very experienced judges who really just providing comments on what the students, what the participants are doing in terms of their presentations. Not all of the participants in the bid protests are law students. There are going to be some more senior people who are involved. And I encourage you, if you would like to participate in the bid protest and you didn't sign up during our first session, just send me an email now. And during the break, I'm going to be gathering those names, and I'll be calling a meeting tomorrow of those who've signed up to participate in the mock bid protest. Just let me know if you'd like to participate. Just send me an email at cukins@law.gwu.edu, and I'll add your name to the list, and then we'll assign the teams going forward, so the teams can prepare for the bid protest, which will be a week from now. Okay. So I'd like to first turn to Lydia, and Lydia very kindly joins us. Lydia Hoover very kindly joins us every year in working through our state and local procurement class. She's an assistant attorney general in the Maryland AG's office. She's been there for 11 years. Before that, she was a contracts manager and counsel for a contractor. She also had 8 years at Rivkin, Livingston, Leviton, the firm that is now Rivkin, Livingston, Leviton, and Silver. And she's also worked as a adjunct professor at the University of Baltimore Law School. Lydia very much is our bridge to the Maryland procurement bar, and we've been very, very grateful for her involvement with our program. Because it creates a bridge not only for our learning, like we're having this evening, but also a bridge for our students who want to practice in Maryland procurement after they graduate. So we're really grateful for Lydia and for professionalism in helping to build these bridges. So Lydia, I want to walk through these questions with you. We're really going to focus on issues of Maryland state procurement law here, but a lot of the issues, Lydia, are ones that are global ones. And so the first question is, under Maryland law, the Maryland State Board of Contract Appeals, and we're going to, by the way, have 2 judges participating from the Maryland State Board of Contract Appeals, administrative law judges in the next few sessions. But the Maryland State Board of Contract Appeals is an administrative forum that hears both bid challenges, bid protests, and also contract administration issues. This is in the federal system. It's kind of like this way, and it kind of isn't this way, Lydia. So, Lydia, the GAO, the Government Accountability Office, hears about 2,000 protests every year, but it only hears formations issues. It doesn't hear administration issues. The Court of Federal Claims hears both contract formations issues and administration issues. How do you feel about this kind of mixed jurisdiction, Lydia?
So I find this question interesting. And first of all, I have to say thank you, Chris, that I really do appreciate talking to your students. And I thank you for the invitation here. And I just want to emphasize that while I'm an assistant attorney general, any opinions really are my own. I don't speak on behalf of the Office of the Attorney General in this session, and I definitely don't speak on behalf of the Attorney General. So I just want to make that clear for my own ethical restraints that I have being in the role that I'm in. And when you had sent me this question, I thought it was interesting in part because I've been doing Maryland procurement for so long, it just seems so normal to me to go to the Maryland State Board of Contract Appeals and have disputes heard, whether they're related to a bid protest appeal or a contracts claim appeal. And I was thinking about this a little bit more after you had sent the question. And I think that one of the things that you and I have discussed in the past is how, what I will say, robust Maryland's system is for dispute resolution. So the Board of Contract Appeals here's the bid protest appeals, but unlike some jurisdictions, it's not just on the record. I mean, you can have a dispositive motion. It can be heard on documents people submit, but you can have a full hearing with witnesses, with cross-examination, with requests for production of documents. So in that way, it's not so dissimilar from contract claims, although you do have more of the discovery mechanisms, you have a more robust litigation structure. But I think it does make sense given how the system is set up with the hearings that are available to the appellants, whether they're a protest appellant or a contract claims appellant.
So I was actually talking. I'm working on a federal study of the Defense Department's bid protest, and one of the questions that's come up is a question of the record. The record in front of the Court of Federal Claims is a record that's referred to colloquially as an APA record, Administrative Procedure Act record. It's a more complete record than you get in the GAO. In the GAO, the record tends to be limited by the agency. The agency makes its own determination as to what's relevant. In terms of the Maryland board, when you have live hearings like that, which are very, very rare in the Court of Federal Claims, Court of Federal Claims is you're very unlikely to have an opportunity to cross-examine. A protester is unlikely to have an opportunity to cross-examine a contracting officer. Do you find that including that cross-examination, including the ability to orally examine the contracting officials, does that change the dynamic from having just a pure paper record?
Oh, for sure. I think that it does. And you have to remember too, that at least how Maryland operates is that the main discovery mechanism in bid protest appeals is request for production of documents. You don't have interrogatories. You usually don't have depositions. It has been extremely rare that there's a deposition of a procurement officer. And I'm lucky enough to have had one of the depositions of a procurement officer. And I think it was because it was a novel issue before the Board of Contract Appeals. And they wanted to really make sure they got it right because it was a relatively new section of law that they needed to decide. But I will tell you, in 24 years, I have had firsthand experience with one deposition of a procurement officer in a bid protest appeal. So how that changes the dynamic for the people who are litigators out there is if you are the appellant, you're going in cold and you're essentially conducting a deposition on the record in front of the Board of Contract Appeals, trying to glean information from the procurement officer, perhaps another official who is going to testify to try to help you prove your case based upon the documents that you have. Some people don't call the procurement officer. Most contractor or most of the protest appellants will call the procurement officer because there are some evidentiary and legal reasons why they want to do that. But it puts the people representing the appellant kind of in a tough situation. And I started out my career in private practice where, I would be the one filing the bid protests and then getting to the hearing and having, a list of questions to ask the procurement officer, and you weren't necessarily sure what she may say, although you had perhaps plenty of documents to support your position or back up the answer that you think you should be given. And then now when I represent the government officials, you're prepping your witness for something that's kind of like a deposition, but it's really a cross-examination in front of 3 board members in a setting that really looks very much like a court. So it can also be pretty imposing to people who have not been in a court-like setting before.
So part of the discussion, Lydia, internationally is a working assumption that within 20 years, let's say at most, all information from a procurement is going to be automatically transparent to everybody all the time. It's the open data assumption. Would that cause a violent change in the Maryland system if all information were available at all times?
So I'm not sure that it's possible for all information to be available at all times. And I think maybe the easiest example of that is I think most of the people who have registered are probably familiar with the difference between competitive sealed bids and competitive sealed proposals, right? So in Maryland, like a lot of systems, when a bid comes in, you have a public bid opening, there's a lot that's pretty public almost immediately. Maybe it takes a little bit of time, a day or two to get the documents, but it doesn't take that long. Competitive sealed proposals are just a different animal because what you have is you have a vendor community, and especially on very complicated matters, the vendors are submitting their proposals with the understanding that their confidential, commercial, and financial information is going to remain confidential, at least through the procurement, if not forever. And so I'm not sure that there is a way to take into account that type of confidentiality concern and also make information immediately available. And then the other thing that you have is that sometimes within the agencies, you might have some type of privilege involved in communications. So one of the things that is required for procurement officers in Maryland to keep is something that we colloquially refer to as a procurement file. And it means every bit of correspondence, every communication related to the procurement. But there may be an awful lot of things in that procurement file that fall under some type of privilege. So for instance, just the most common one, attorney-client privilege, because as a solicitation is being drafted, agencies often consult their attorneys for guidance in looking at the terms and conditions, giving feedback, looking to see if there's something wrong, something legally wrong with the solicitation before it gets issued, that there is a level of review. So I used to do that when I worked directly for some agencies, and my changes and my comments wouldn't be something that would be disclosed, even though it might sort of be part of the procurement file at some point, not necessarily during the solicitation drafting, but once the solicitation is issued, questions and answers come in, and sometimes legal advice is sought about how to respond to some of the questions, or the questions come in, and then legal advice is often sought regarding how to answer some of the questions if they get into something a little complicated, technical, and potentially legal, with legal ramifications.
So I hope Mike's taking lots of notes because this is going to be a major issue for us in the model procurement code question. How do we frame this up? Including, Mike, one of the issues that we're dealing with in the report that we're preparing for the Defense Department is how do we deal with agency level protests? Agency level protests have almost no administrative record in the federal system. Do we take the administrative record requirements from the Court of Federal Claims and move them back into the agency level protest so that the full record is available from the beginning, working against this long-term presumption that administrative records of this type will be automatically available to members of the public? So
yeah, and it's interesting too, because that's the agency level, but when we get to the Board of Contract Appeals, that if there's something having to do with a proposal where the proposals of different offerors are submitted or discussed, that it's pretty common to enter into a confidentiality agreement so that attorneys can see proposals of other offerors, but the executives or other people at a particular offeror can't see the proposal of another one. And it's not uncommon for some, or I guess in some cases, all of a hearing to be closed if you're really talking about a lot of confidential, commercial, financial information.
and this is actually an issue that the Europeans are struggling with as they build their build their protest systems, because they don't have a ready system for protective orders. And the GAO creates sort of a bubble around a protest, and everybody can get inside the bubble. The council can get inside the bubble, but they're making it up as they go along in Europe. In Lydia, do you find that a non-disclosure agreement is enough to secure the confidences within the circle?
So, I mean, I would say yes. I think that confidentiality agreements have been, or orders have been in place for certainly as long as I've been working at the Board of Contract Appeals. And it used to be, the parties would come up with their own, or maybe the Board of Contract Appeals would issue one. And what the Board of Contract Appeals did recently, or in recent years, is they actually have a form agreement online for attorneys to just start working from, because it's one that has a lot of the common terms and conditions that people want. And generally what happens is it's very confined to counsel of an offeror, and occasionally an expert who's going to look at some of the information, because some of these proposals and some of these solicitations are really complex. And I know that I need my clients to be able to explain them to me. And when you have the attorney on the other side who might be representing the protester, they can speak to some things, but sometimes the attorney just needs assistance if they're trying to look through a different offeror's proposal.
So I want to take that and then down to the next question. In the federal system under FAR 33.103, an agency level protest is not a prerequisite to going to the GAO, to the Court of Federal Claims. But on the next section, under FAR 33.104, for claims under the Contract Disputes Act, there is an exhaustion requirement. You have to go to the contracting officer first, and only after you get a decision from the contracting officer, then can you go to the Board of Contract Appeals or to the Court of Federal Claims. In Maryland, there's an exhaustion requirement on both protests and claims. Do you think there should be an exhaustion requirement for protests?
I do, because I think that protests filed that raise issues can sometimes lead to a change in decision or a decision from a procurement officer. So I think that the agency, it makes sense for the agency to have an opportunity to maybe reconsider a decision that it's made, or have a suggestion of a decision that it should make. And I was thinking about this, and I can think of, a couple of examples. That my very first bid protest that I had in my career, I represented a bidder whose bid had been rejected for what we indicated was a minor irregularity, that it did not conform 100% to what the bid document said, but we said it was immaterial. We submitted a bid protest on behalf of the contractor, and the procurement officer said, "Oh my gosh, you're right. We are going to say that you are no longer rejected, and we're going to rescind the notice of recommendation of award to somebody else, and we're going to decide in your favor." And I think that what really happened there is we submitted a bid protest first, and then we submitted a supplemental bid protest, and the procurement officer changed his mind. And then the now disappointed bidder filed something at the Board of Contract Appeals. They were not successful in their bid protest. And there's another instance that I can think of where a potential bidder filed a protest with the procurement officer, essentially asking, who wrote your specifications, because we think there was input from another vendor. And the procurement officer didn't know that. And it caused the procurement officer to conduct an investigation and an inquiry and make an appropriate decision in light of the information provided by the protester. So I think that there are opportunities for the agency to make decisions based upon that protest. And I think that that's how the exhaustion really makes sense. And even more so is that any kind of an initial determination by a protester to make, a procurement officer to make any kind of a decision is often done by the procurement officer. But after a protest is filed, when the procurement officer drafts a final decision of the procurement officer, that actually has to be reviewed at a higher level within the agency by somebody called the reviewing authority, which is like an agency head or designee that it's often, sometimes it might be a secretary, sometimes it's a deputy secretary, but it's somebody high level, and there's supposed to be consultation with the Office of the Attorney General. So there really is this internal process for the agency to make a decision one way or the other before it's protestable or it's appealable to the Board of Contract Appeals.
Well, that leads to my next question, Lydia. So one of the problems in the federal agency level bid protest system is if you file an agency, this is the thing that terrifies practitioners, you file an agency level bid protest, and then the agency might not do anything. They only are supposed to respond promptly. Like the same problem exists under the NPC. It's a prompt response. And so the agency, if the agency doesn't do anything, but then does something, doesn't respond in writing, but does something to make it clear that they've just rejected the agency level bid protest. For instance, they go forward with the procurement. GAO considers that action as a trigger for the 10-day filing deadline at GAO. So there's no written decision. It's a non-decision. And GAO says, oh, that's enough to put you on notice that you should file the GAO. Your 10 days has begun to run. And that creates a malpractice nightmare for lawyers. So which is one of the reasons that people don't use agency level bid protests. Is the same true in Maryland?
No.
You have to have the trigger for an appeal has to be a written decision.
You really need a final decision of the procurement officer.
Okay.
And they're to decide protests as expeditiously as possible. That's what's in the regulation, is as expeditiously as possible. And sometimes that varies, right? Because if it's a very complicated matter, it might take a while to issue a final decision on the protest. It might be a simpler issue where a protest can be turned, or a final decision can be issued within a week. It really just depends on what the issue is. And I did pop into chat, and I see that somebody had asked about whether it's common for both FOIA requests and discovery requests from the same protester. And yes, that is common. And what really ends up happening is once you're in litigation, once you have a confidentiality agreement in place, you sometimes have access, at least some of your agents have access to more documents than you might be entitled to under Maryland's version of FOIA, which is the PIA.
And I think Liz has something on this as well.
Yeah, I just saw hers too.
I wanted to jump in because I thought it was a really interesting question, Chris, like one that, as you said, would strike fear into the heart, is I think of most practitioners, to require an agency level bid protest, not only because of the issue you raised about the timing and the deadlines for filing at the GAO, right? But I think most practitioners would probably view that as a waste of time, right? You're asking the agency official who already awarded a contract to somebody else to second guess themselves, which I think is different than the claims context, and probably why there's a difference in the rules, where in the claims context, the contracting officer has already been administering that contract, has unique knowledge of the contract, the reasons why you think you should be paid or not paid under that, right? And so they're in a unique position to look at those facts, handle those, and then let it go up to one of the boards of contract appeals at that point in time if it can't be resolved below. But I think that's different than at the protest stage, where you're really seeking an objective point of view as to whether or not the process itself was fair from a completely objective third party. So to me, that would be really problematic. I think also it would raise a lot of questions about the stay of an award. So if you represent, we represent both protesters and interveners. And if I'm an awardee, I'm going to worry, now I have to wait for the stay of the agency case, right? How long is that going to take? Then I have to go to the GAO. Then maybe it's going to go up to the Court of Federal Claims. I mean, years could go by before I could actually start performing. And of course, there's like CEQA overrides, but is that going to happen every time? To me, that would really be to me just a drawn out duplicative process that I would really hate to see as a requirement.
Yeah, our interviews for the DoD research that we're doing they're not for attribution, but I can say that what's been interesting is that senior, obviously, private practitioners, Liz, take the position that you do, unsurprisingly, that there shouldn't be an exhaustion for all the good reasons you put forward. What we were surprised at was the senior lawyers in the agencies and in the adjudicating fora also took the same position, that they didn't want to see, at least at the federal level, they didn't want to see an exhaustion requirement. I should make clear that the report that we're writing actually is going to be a report from the Secretary of Defense to Congress. So you can imagine how circumspect this report is going to be, because we're basically, whatever we write, then the Secretary will vet and will bring forward. So it's a very cautious report by necessity. Okay, the next question goes to questions of priority that Lydia, the Maryland law calls for the board to give priority to appeals of a protest over appeals of a claim. How does that work in practice? Do they just how do they deal with this conflict between the two?
So I'm not sure how often there really is a conflict, but I do know that it seems that the board really tries to have protest appeals heard very quickly. So whereas if you're in a claim situation, what you're doing with what I would do with my opposing counsel is we would come up with a scheduling order about things like, when is your discovery deadline? When is the dispositive motion deadline? When, do we want to have a pre-hearing conference? And what is our suggested date for a trial? And in a claim, especially complicated claims, that might be 12 months, 18 months, 24 months down the road. And that's not going to be doable for a bid protest appeal, because it is something that you want resolved quickly, because there's an understanding that whatever these goods and services are, the government needs them on behalf of the taxpayers. So you want this to be able to move forward. And then you have all of these different stakeholders with various interests. You have the government, you have the taxpayers, you have the protester. If there's been a recommendation of award, you have the interested party. So the idea is really to resolve things as quickly as you can.
So we talked about discovery. So I want to get to the next bullet, which has to do with the recovery of costs and attorney's fees. The model procurement code is very, very stingy in terms of the types of remedies that it allows. But Maryland normally can allow costs, but attorney's fees if the contract claim was in bad faith or without substantial justification. Is it relatively common to see attorney's fees being awarded at the board?
No, I cannot remember a time where maybe there is a decision out there that exists, but I actually can't remember when that has occurred.
Okay. There's a working assumption on the part of folks at GAO, certainly folks that I've interacted who've thought that the remedies at the federal level are an important part of the protester's decision to protest. Whether or not you get bid and proposal costs, or you can get fees, et cetera. Lydia, you've worked on both sides of the line. When you were working with contractors, when they're making the decision to protest, do they ever think about these other possible remedies, or are they really focused on the award of the contract itself?
So what you can get in a protest are costs. You're not getting attorney's fees. You're not getting the time spent to draft a proposal. You're not getting if you have your director of such and such testify, you're not getting his time. So depending on the situation, the cost could be very narrow. And while I'm certain that when I was in the private sector that contractors would have wanted the ability to get attorney's fees, I'm not sure that that was ever a deciding factor in filing a protest or not, because the decision to file a protest tended to be that if you listen to the contractors, they thought something went wrong in the process, or it's not necessarily something went wrong in the process. Maryland also has a solicitation bid protest. So in Maryland, you have to file a protest based upon an impropriety in the solicitation prior to the submission of your bid or proposal. And then anything else has to be filed within 7 days of when you knew or should have known. So sometimes protesters would file a protest alleging an impropriety in the RFP because they think something is wrong with the specifications. And the idea is, let's get these specifications changed or modified or clarified so that we really know what we're competing on. And from them that they want to be treated fairly. And then for other things, it's usually the allegation is, well, something went awry in the procurement process itself. So with proposals, it would be the evaluation was somehow flawed because I, as the best vendor in the world, I was not chosen. So something must have gone wrong.
So Mike, did you have a comment?
Yeah, I think it's always interesting when you shift the American rule and make and make fees available, right? And I think one of the concerns that some of my contemporaries have had is that if you make fees available, and we've had very, very, very few protests, right? But if you make fees available, then you create a group within the bar who pursue that business, right? Like the class action bar groups, right? So you have all of a sudden people who would pursue it essentially on behalf of the legal fees, not on behalf of the solution. And that's always an interesting concern when you're thinking about those kinds of remedies.
Yeah, and then to flip it around, Mike, and when you talk to the English lawyers, you say, well, in your system, you can get anticipatory profits, you can get fee shifting. This is a lot of other possible remedies. And they say, yeah, that's great, but what we really care about is the contract. Our clients only care about the contract. They're focused,
Yeah.
as Lydia's been suggesting, on that. And so, because this is like a whistleblower system. The question is,
Yep.
what do we need to make the whistleblower system work? What incentive do we need for the whistleblowers? I think it's the contract. I think that's the key.
Yeah, I think so too.
So Lydia, we're running a little short on time. Do you want to address the questions we have here at the bottom of the slide, the MBE
Okay.
questions?
Oh, okay. So MBE is just something, I know that you were talking about how to avoid bid protests. And one of the things that seems to come up just in Maryland is that Maryland has taken a stance that one of the socioeconomic policies that it really cares about are MBE, minority business participation. The statewide goal for MBE in the entire state for all procurements is 29%, which when I looked at this several years ago, it's been a while that I looked at it, Maryland had the highest goal in the nation among the states. I don't know if that's still true. I haven't updated what I had done just kind of for my personal use. But one of the things that Maryland requires is that if a solicitation has an MBE goal on it, the bidder or offeror must use good faith efforts to meet that MBE goal at the very front end of the solicitation process. And they actually have to name their MBE subcontractors up front that they will use if they are awarded the contract. And what we've seen is that there are mistakes that occur in the submissions of the MBE forms that get attached to a solicitation, that sometimes they're just errors that a vendor made because they didn't understand things, but it might be an error that's so grave it requires a rejection of the bid or the proposal. So when you're talking about avoiding bid protests, MBE is one of those areas where I would just use that to emphasize that there are certain things that really have to be submitted with your bid in your proposal, and sometimes those things are not correctable. Sometimes they are, sometimes they aren't. The other thing I had put on that bullet point, because we had talked about this before, is the assistance with drafting specifications that will disqualify a bidder or offeror, but that flows down to their potential subcontractors too. And I think that this is interesting in Maryland because for years and years, the assistance with specs provision had been something that would be decided by the Maryland State Ethics Commission. And several years ago, the General Assembly shifted that back to the procurement statute so that what has to happen is the procurement officer makes a determination as to whether somebody assisted with specifications and they are therefore disqualified from being a bidder or offeror. And then that is the decision that can then be protested and then appealed to the Maryland State Board of Contract Appeals. And that came up a few years ago. It was the first decision that the Board of Contract Appeals had to deal with regarding assistance with specifications. And it's just kind of an interesting thing because after, decades, suddenly this is an issue that the Board of Contract Appeals has. And I guess the final thing was that, I think it was Missy who was talking on Tuesday about things like just being aware, because she practices in so many jurisdictions, and being aware of the landscape and things like that. Maryland has a unique thing that in its procurement, its procurement laws, that it has a constitutionally created body that's composed of the governor, the comptroller, and the treasurer, called the Board of Public Works. And I'll just call them large dollar contracts, generally procurement contracts, $200,000 or more, sole source is $100,000 or more, and change orders, $50,000 or more, all go to the Board of Public Works for approval. It is a public meeting with a public agenda and an agency, and until the Board of Public Works approves it, with the exception of emergency contracts, it's just a recommendation for award. So an agency can get through a procurement, they can get to the Board of Public Works. The Board of Public Works might have many questions, and the Board of Public Works could say, no, we don't want to award that procurement contract for whatever reason it may be. So in Maryland, for the larger dollar items, you really don't have a contract in place until the Board of Public Works approves it.
That's an anti-corruption device in principle. This dates back to Spiro Agnew, doesn't it?
Yeah, so Maryland's procurement laws really were created post Spiro Agnew. He had worked in, local government. He had been governor. He became vice president, and then he resigned from being vice president. And there were all these scandals associated with bribes that were given. And then it was in around 1979, 80, where the waiver of sovereign immunity came in, the procurement statutes were put in place, and then there were all of these things put into place to try to really ensure that not only could you get competition, but you were ensuring fair treatment of the vendors who are doing business with the state or who want to do business with the state. And maybe as important as just general fair treatment is that you have a system that has integrity so that you do encourage that vigorous competition, so that the vendors out in the community who have an opportunity to bid on things in Delaware or Virginia or the federal sector will say, hey, I'll bid in Maryland because even if I don't win the contract, I know I'm going to be treated fairly. And those people do things the right way. I mean, hopefully that's what vendors think.
The flip situation is right now, the flip situation true right now in Delaware, there's a senior constitutional officer who's facing possible impeachment from the state Senate or removal based upon misuse of procurement authority. So we keep learning the same lesson over and over again. By the way, on your second point is really interesting, Lydia, that organizational conflict of interest issue. 2011, Dan Gordon, who was then the head of federal procurement, wrote a proposed rule on OCIs that would have shifted a lot of organizational conflict of interest issues you've identified here, away from the procurement process into something more like an ethics process under FAR Part 3 would be an integrity question. And that lay sort of dormant. Nobody grabbed onto it until 2021 when the Biden administration withdrew it. But now, because of a separate scandal going on the Hill, there's proposed legislation, and that's included in the resources. The last resource that is an article by Alan Shvatkin on the program page, and it talks about the proposed legislation that would revive that approach, shifting things from the procurement column, organizational conflict of interest, from the procurement column into the anti-corruption column. So this just straddling between the two worlds.
Yeah, it's interesting. So who knows if it will remain residing in Maryland in the procurement section, or if the Ethics Commission will get it back. I'm not sure the Ethics Commission will get something like that back, but I don't know. Oh, I'm sorry. I was going to say, there is a question. Does an MBE have to sign on to just one primary bidder? I don't think that that's a requirement at all. I'm going to say maybe there are caveats, because you do want to make sure that there isn't collusion. But if you have something like, I don't know, you're using printing services, or it wouldn't be uncommon, or if you're in the construction context, one of the big industries for MBEs might be flaggers, traffic control. It wouldn't be uncommon for there to be one of those somewhere that maybe each of the contractors wants to use.
There's also a comment on Maryland's reputation for corruption, but we'll leave that alone. As a Baltimore resident, I can point out that the DA is actually married to the head of the city council in Baltimore, so I'm not even going to touch that one.
Yeah, I'm not touching that question. I'm unaware of that happening during the governors that have been governor while I've been at the office of the Attorney General.
I do want to just touch on this minority business thing, because it's kind of interesting. The Europeans struggle with the same question. They set up their defense procurement directive so that member states can force primes like Lockheed to name their subs before award. And so that you choose, if Hungary's buying Lockheed Martin jets, you can choose Hungarian subcontractors. That's the idea. But that it limits the ability of the primes to negotiate aggressively with the subs. That's why we have teaming agreements at the federal level, because you don't want to get married before you have the prime contract, because your negotiating position strengthens once you have the prime contract.
That's right. That's right. And that was the Maryland law was intentionally changed to prevent that post recommendation of award and post award negotiations, because originally the contractor didn't really have to name all of their subcontractors, or if they did have to name them, they didn't have to really be committed to them. And what happened was that the MBE community complained that when they were taken on, they would essentially help a potential prime win a bid, win a contract, and then they were subject to shakedowns after the fact, because before the law changed, the bidder or the offeror, who's going to be the prime contractor, didn't have to have a commitment to that particular subcontractor. They might have used their pricing, and then they could have gone out and shopped around, or whatever the pricing is. If they might ask for a discount and say, well, if you don't give me a discount on this, you're not going to be a part of this contract. So the change in the law with the naming at the front end was to try to get rid of that, because these MBEs, remember, they're small businesses that they have the minority designation, but they're also pretty small businesses that might not have the same type of negotiation power or leverage that the prime contractor does, especially if it's a big contract and a large contractor.
Okay, I've asked way too many questions, Lydia, so I'm going to have to go on.
Okay.
Let's go on, and we're going to have Bill Curry. Bill Curry is a principal consultant at WSC Consulting. He's a prolific author, and we're drawing, as I mentioned before, drawing on a forthcoming third edition of his book, Contracting for Services in State and Local Government Agencies. He's developed contract management software that's used in one of the top 10 cities in the United States. He's a former Air Force Systems Procurement Officer, and he worked at various nonprofits and traditional government contractors. So he has a lot of experience he's bringing into these books. And so, Bill, I want to turn it over to you, and thank you very much for joining us.
Okay, thank you. The reason I wrote this book was I went to work as a county general services director, and after I'd been there for a while, I realized that the people who were working on contracts, none of them had even had a basic course in government contracts, and they were pretty much learning their job on the job. And it was really a lot of confusion as to exactly how government contracts work. So I decided to conduct some courses, and I started putting together a lesson plan. And as I was writing the lesson plan, I realized that it started to look like a book. So I contacted the publisher, and they said they were interested in publishing a book in government contracts. So they gave me a contract and got started on it. And my intention was that it was going to be a book used primarily by state and local government agencies to train their personnel. However, the primary customer of mine are university professors, and it's used as a textbook. I'm going to talk primarily about what happens when you actually get a protest and how you react to it as a government procurement officer. Before I get into that, though, I'd like to make a few comments on preventing protests. And I think that the main thing is to have a transparent request for proposals. And this helps establish a trust between the government agency and prospective contractors. The transparency recommendations that I would make are, one is include the process for requesting debriefings and filing a protest in RFPs. Also, describe the process for managing communications by directing all contractor questions to one person in the procurement office. And preferably for those agencies that are using e-procurement systems, those questions would be posed online so that there's no one-on-one communications between the contractors and the procurement officer. I also recommend that in the request for proposal, that the evaluation criteria be listed, and that the criteria have numerical weights that are also included in the request for proposal. And that's so that when you're evaluating it, you can do a numerical calculation to determine who is the best contractor. And of course, that requires formulas for weighing the proposal scores. And so I'm recommending also that the equations for weighing those scores be included in the request for proposal. And it was interesting, when I was doing my research, I found that most of the contractors in state and local offices are using this approach. However, they the one for weighing price, it's a little bit of a complex formula, because not only are you weighing it, but you're converting a low price to a high score and a high price to a low score. And almost all of the contractors, or I mean, almost all of the government agencies were using anomalous formulas. And of course, that would distort the score, and they could conceivably collect or select the wrong contractor because of that. And despite these measures you might take trying to prevent protests, however, there's going to be some protests that are going to be received regardless of what you do. The recommended policy for protests sent directly to the procurement office is to notify your legal counsel that you did receive a protest. And I came up with a 8-step program on exactly what you do in order to make a decision on the merits of the protest. Starting with step 1 would be to read the protest and begin drafting questions to ask of the proposal evaluation team members. And sometimes I will refer the proposal evaluation team members as PET members because I stumbled over that anyway, trying to say that. Anyway, one of the steps I will discuss later is the interview and how to conduct the interview with the PET members. I recommend starting a list of questions during this first step, and then to modify that list of questions as you go through the following steps. And step 2 is to read the request for proposal, paying particular attention to the criteria that are used for evaluating proposals. And I would make note of those criteria because they become very important as you go through the evaluation of the protest. Also, I recommend being alert to inconsistencies between the source selection process described in the request for proposal and the contractor's objections to the source selection process. If questions arise during the reading of the RFP, I would, of course, add those to the list of questions that you started during step 1. In step 3, read the proposal evaluation term instructions or team instructions. Inconsistencies between the PET instructions and the solicitation should be noted. Such inconsistencies will likely illustrate a divergent proposal evaluation process. You have to ensure that the criteria descriptions from the RFP are available to the PET members. A list of questions begun in step 1, of course, needs to be revised again upon completion of step 3. Step 4 is reviewing the procurement policy and procedures for evaluating proposals. This step is intended to identify any consistencies between the PET member instructions and the policies and procedures. And again, update the questions for the interviews. Step 5 is to review the record of evaluation of proposals by the proposal evaluation team members and determine whether the PET members complied with those instructions. Ensure that all criteria listed in the RFP were evaluated, and ensure that only those questions listed in the RFP were evaluated. And oftentimes you'll see it's a big problem if you list 7 or 8 criteria and then the proposal evaluation team actually looked at 9 or 10. You have to ensure that proposal evaluation team members use the criteria that were described exactly as they appear in the request for a proposal, and ensure that the proposal evaluation scores were weighed with the weights in the RFP and with the formulas that are in the RFP. You have to ensure that the price and life cycle costs were evaluated as described in the RFP again, and ensure consistency between the PET member instructions, the procurement policies, the record of the proposal evaluation process, and then update questions for the proposal evaluation team members as necessary. Step 6 is to edit the questions that were started during step 1 and refine through steps 2 through 5, and then organize the questions in a logical sequence for conducting the interviews. Step 7 is to interview the members of the proposal evaluation team. I suggest interviewing a minimum of 2 PET members during each discussion, and this oftentimes you'll find an interesting discussion between the 2 of them as they're answering the questions. During the interview, you should strive to develop an understanding of what occurred during the evaluation of proposals, determine the validity of the proposer's objections, and determine whether the proposal evaluation was conducted as described in the RFP, that it is consistent with the proposal evaluation team instructions, and complied with the procurement policies and procedures. And during this time, it's a good idea to mentally evaluate each PET member's dedication to identifying the proposal that represented the best value to the government. Step 8 is to synthesize the information gathered during the earlier steps. During this time, you can consider a second review of the protest, the solicitation, instructions provided to proposal evaluation members, your agency's policies, record of evaluation of the proposals, and finally, I suggest a review of the notes from the interview of the evaluation team members. Then you can make a determination on the merits of the protest, draft a letter notifying the protester of your determination, coordinate your letter with legal counsel, and then send the letter. I went through this process on one protest that I received, and I'll tell you what happened during a real life evaluation of proposals. The protesting contractor claimed that the proposal evaluation team did not evaluate proposals according to the criteria in the RFP. Based upon the research that I conducted in writing the books, and also my personal experience as a general services director, I found that the most common reason for filing a protest is failure to evaluate the proposal according to the criteria. The RFP in question was prepared and proposals were evaluated jointly by two departments that had delegated authority to release the request for proposals, evaluate proposals, and then submit the contracts to the governing body for approval. When this was done, once the contract was awarded, the protest was submitted and directed to the general services director, so I received it. The two departments that evaluated proposals consisted of a behavioral health department and a law enforcement department. I felt that I conducted the interviews in a non-confrontational manner, and it went very well with behavioral health department. One of the two law enforcement representatives, however, appeared to feel that his role of interrogating suspects was being reversed on him. And he was starting to get a little agitated during this time. The other law enforcement representative, who was his superior officer, calmed him down on several occasions during the interview. So this is the sort of thing you might run into if you're going through this process yourself. The RFP was based on a template that was provided by General Services, and that RFP included some sample criteria which the departments were recommended to consider. The RFP in question actually used the sample ones almost verbatim. However, they made a few minor corrections to them, which was unusual because they're usually tailored more towards individual procurements. Despite the RFP criteria deviating from the criteria in the template, however, the evaluation was based on the criteria in the RFP template. So there was this, they did vary from it. However, it was really a very slight variation. And my determination was that the proposal evaluation team selected the contractor offering the best value to the government, despite the slight variation to the criteria, which I determined to be an error and not intentional. My letter to the contractor agreed that there was a slight variation, and my feeling that it was made an error and it was not intentional, and that if they had evaluated exactly according to the criteria that was in the request for proposal, they would have selected the same contractor who was a competitor to the protester. The contractor did not complain about the determination and did not appeal the decision to award the contract to the contractor's competitor. So it worked, and I've pretty much stuck with that same process for evaluating protests.
So a couple different questions, one, Bill, and one I'm gonna bring in Lydia on one of the questions. So the first one is, I think you've answered already. Do contracting officials feel that protests are insulting or disruptive? Does it create sort of personal anger and angst on the part of contracting officials?
Yeah, I think it pretty much does, because they feel that their integrity or their professionalism are being challenged.
In that regard, what you're describing here is what at the federal level what would be done by an agency counsel. And Lydia, the question I have for you is, if a non-lawyer does this investigation, as the agency counsel coming in at the end, as a can you protect this investigation under some sort of work product or deliberative process privilege?
So I'm not sure when someone outside of the agency would do that, in my experience.
But if somebody inside the agency, let's say a senior agency official does, as Bill's been describing, senior agency official has a protest come in and does this type of analysis, which would done at the federal level would be done by a lawyer. So you've got instantaneous privilege. If a non-lawyer does it, can you protect it?
I think it's going to depend on what it is, right? Because if they're discovering facts and documents that are otherwise disclosable, then no. But if they're actively working with their lawyers in anticipation of litigation, maybe there's some sort of other privilege that attaches. Maybe it's really going to depend on what it is. But normally what happens is that, someone will conduct some sort of an investigation, often hand in hand with while getting legal advice about things, because your client may say to you, oh, well, I discovered this, or maybe you get a bunch of the documents and you say to the procurement officer, well, did you look at these particular things? And if so, then what's your decision on this and what's your determination? And I know I try very hard to provide advice and sometimes be a sounding board for things, but ultimately certain things are going to be within the discretion of the agency to make a decision, so long as it isn't arbitrary, capricious, unreasonable, or violation of law. I'm not sure if that answered your question, other than being a legal answer of it depends, because it really is going to depend.
And to raise a red flag for folks to get involved, the agency counsel involved as early as possible, so we can think through these privilege issues. Bill,
Definitely.
Bill, my last question goes to, so Bob in the second hour, we're going to take a short break in a second. Bob in the second hour is going to be talking about the fact that in a what we would call competitive negotiations at the federal level, and what Lydia referred to as competitive sealed proposals, and under Maryland law follows the terminology of the Model Procurement Code. In that situation where there's a statement of goals by the agency, but you could get very disparate proposals. At the end of the day, a very closely calibrated scoring system may not fit the situation. Like when I went and bought my last car, Bill, I didn't know you could get reverse cameras. I just didn't know they were a thing. And so if I had a scoring system that my scoring system wouldn't have included reverse cameras, but when I saw them, I said, holy cow, this solves all our parallel process and parking problems in our family, which will go undescribed in greater detail. But these reverse cameras are incredibly useful. So I would want to include, but it's not in my scoring matrix. And so the sealed proposals or competitive negotiations, by definition, means that there's a disjuncture between the initial scoring system and what the market may propose. Did your case study prove that, Bill, and that you have to have some flex because ultimately the agency may discover new things in the marketplace?
I think that the way you could build in the flexibility for that sort of thing is to have one criteria is say features that are offered over and above the specifications or the proposed statement of work.
That's good. Professor Secret, that's actually how I grade papers, Bill. So it's a great solution. Okay, so why don't we go ahead and Bob, we're going to open up the floor to you and to Liz after the break. We'll just go take just a 5-minute break till about 14 past the hour, and then we'll come back in. And I apologize, we're a little short on time, but we have a lot of interesting stuff to talk about in the second hour. Thank you all very much for a fascinating first part of this. Thanks. I'll see you in about 5 minutes. So Liz, are you with us?
I am here.
Terrific. I'm going to go ahead and just do your intro. Liz Levy is a partner at the national law firm of Reed Smith, international law firm of Reed Smith. She does protests at GAO, the Court of Federal Claims, and she's done a number of protests at the state level too, which is really why we're very glad to have her join us here this evening. She got a BA from GW and she got a JD from Cornell Law School. She was the founder of the National Security Law Society there at Cornell. And she was on the Journal of Law and Policy at Cornell, which is a very important journal in the law school world. So we're very glad that she could join us. And she's going to talk a little bit, just a couple slides talking about her experience, her practical experience, and some of the issues that have come up in state bid protests. And reviewing these questions, I was really struck by how much they speak to possible systemic reforms across the country. So Liz, the floor is yours.
Thank you. Nice to meet you all. So I wanted to sort of talk today just a little bit about some of the tips and tricks, both from the protester side and then also from the agency side, kind of looking at it from two angles. Obviously, I represent contractors, so I am typically on the side of the protester and the intervener, both at the federal level and as well as at the state level. But there's a lot of commonalities that we see both at the federal and state level and across jurisdictions that, you know, I would love to see my clients do differently, and that we would love to see state agencies do differently, that we think would either avoid bid protests or make them work better to get results that both sides can live with. So I'll just kind of frame the discussion with those points in mind. So, you know, talking first a little bit about just commonality themes that we see about how you can avoid bid protests if you're a protester, right? And so when we get to the protest stage, we're normally thinking about the post-award protest, right? And what I have up here are sort of things that the protester should be, that the contractor really should be thinking about as they're drafting their proposal, you know, as they go through the process. What's not up here, sort of the other things that you can do before you get to the proposal stage, before you actually submit your proposal, draft your proposal. The first is to really take advantage of the Q&A process, if that's an availability. At the GAO, at the federal level, that's commonality, something that's there in almost everyone. At the state and local level, it's not something that's always there, but when it is, it's wonderful for contractors to be able to take advantage of that. And from the, you know, I know I'm speaking with a lot of agency officials, so I don't get the opportunity to speak with a lot of the time. And so one thing I would hope to see more and more is providing contractors that opportunity to submit Q&A at the state and local level when you're opening up a procurement, because I think it would avoid a lot of bid protests down the road, right? You may avoid pre-award protests when there's an issue that can be quickly worked out in a solicitation. And you might avoid subsequent post-award protests too if there are issues that then transfer into confusing requirements or just any requirements that sort of present problems down the road. And another thing I will say, since I have so many of you and have your ear on the agency side, is that, you know, what we would love to see more of truly to avoid bid protests is truly a fulsome, responsive process in the Q&A procedure. As I said, it is truly a wonderful opportunity for contractors, but on the same token, even when we have that opportunity on that side, frequently what we get is very vanilla, very template responses that really don't address the underlying concerns raised by the contractor. And to us on the protester side, it really is an opportunity to resolve things. The protester is really previewing for you, the contractors are previewing for you what their protest grounds are going to be later on, whether it's in a pre-award or a post-award basis. And so thinking critically about, you know, what is this contractor asking? Why are they asking this? Sure, sometimes they're trying to steer things in a way that's more favorable for them, but oftentimes they're raising real problems, whether, you know, ambiguities in the contract, favoritism in the terminology, that really can be resolved up front and avoid a bid protest. So it's not on my slide, but I did want to kind of talk to the Q&A process as well, because I think there's benefits really to both sides to try to avoid bid protests by engaging in a very robust Q&A between the contractors and the agency officials. So when I'm speaking to contractors and we're talking about what you can do early on to avoid bid protests, obviously there's not a lot you can do once the proposal has been submitted. So everything has to be, upfront in your proposal. And one of the most common, just really basic, seems so obvious things that we see is that contractors are knocked out all the time because they fail to respond to just even minor requirements. Sometimes obviously it's major things like a page limit, font size. I see this a lot more at the state and local level, even than at the federal level, though it certainly happens there too, that it really gives the agency an easy way to eliminate you if they weren't that interested in your proposal in the first place, right? So if you have, if you're playing favorites, that's just an easy way to knock people out. So, it's just such a way for contractors to try to avoid that knockout, is making sure that you're addressing those minor requirements, your technicalities. Another area sort of within the proposal writing framework is to make sure that you're actually responding to the proposal and the requirements. We see this a lot when we're dealing with incumbent contractors who are perhaps used to things being a certain way under their existing contract, and then receive a RFP, a solicitation that may look very similar, but is actually quite different than the scope of work under their current contract, but they may not pick up on those nuances. They may not address those nuances. And so making sure that you have not only your current performing team reviewing the solicitation and the proposal, but also a B team. It can be an internal B team, it can be external counsel, it can be a proposal writing company, but making sure that you have someone else looking at that proposal to make sure you're picking up on those new requirements or differences from your current contract, right? And similarly, continuing the theme of just proposal writing tips to help avoid protests is one thing we see a lot, and this is again at the federal and at the state level, is when contractors just restate the requirements in the RFP without really demonstrating how they're going to perform the contract. They don't describe the resources, the tools, the tracking metrics that they're going to use, how they're going to successfully carry that out, but they simply restate, section 3.4.1 requires XYZ, we will do XYZ, right? And a lot of times that really doesn't win the day for the agency. They don't have a clear understanding of how the offeror is going to carry out what they say they're going to do. So, I think offerors, we see them just kind of going through the motions sometimes, restating and trying to address, trying to fit within the page limits, which is also always a challenge. But really, we see just so often protesters knocked out because they just didn't provide the how. And so I wanted to just reiterate as a way from a contractor's perspective, a way to avoid that is to making sure. This is another reason why having a B team in place, someone else to come in and say, okay, I know we're down to the wire. I know there's not a lot of time to get this in, but we need to have other people reviewing our proposal to make sure that we are not only addressing the requirements now, but explaining how we're going to meet those. So this is an issue. The next one I want to talk about is a problem that we see at the federal level, but I see even more at the state and local level when procurements are tailored to companies that may have that may be a conglomerate that has operations in various jurisdictions, right? So a good example of this is a managed care organization that has, for example, a parent health insurance company and then sets up a New York entity, a California entity, a Illinois entity to perform the managed care organization's work in that different jurisdiction. And we see this not only at the managed care level, but it's just a common problem that I've seen in particular there. One is that when you are bidding as that state level entity, you may sort of expect that the agency knows that you are part of this bigger conglomerate and that you're going to use the resources of that parent, you're going to rely on the past performance of that parent, and you're going to function sort of as one family. Maybe you're using the HR components or the the payroll system of your corporate parent. But it's very important for the agency when they're evaluating you to make sure that they understand how that parent is going to be involved. And by the same token, as like a issue that we see on the agency side is sort of when the offeror doesn't really explain that very well, you're left without the information you need to be able to credit that offeror for the experience that they not only bring to the table, but their entire family brings to the table. So making that really clear in the RFP can really help if you give offerors directions up front, rather than waiting for them to guess, can we use our corporate parent? Can we rely on our affiliates? In a case where you know that the majority of your bidders are going to be part of these multi-jurisdictional type organizations, it's very helpful to us as council, but also really to the bidders to see upfront, are you going to allow offerers to rely on that? And sometimes we see, in particular at the federal level, we'll see agencies specifically restrict only their offeror can have this experience, only the offeror can have these certifications. And then it gives some clarity to the bidders as to who can bid, where their eligibility is going to fit in, where their experience is going to fit in. But when that's not clearly set forth up front, you're likely going to have protests about, offerors improperly relying on the experience that you didn't want them relying on, or on the other hand, putting everything in there and then you have everything to evaluate. So I think from both sides, that's something that we really would like to see more detail on from the agency side and from the bidder side. The next point I want to talk about was state politics. This is something that really doesn't exist at the federal level, but I can't stress enough how often it comes into play when we're dealing with state and local procurements. I'm probably preaching to the choir here, given the audience, but from a bidder side, from council, outside council side, it is almost unheard of for us to have a state procurement where one of our clients isn't also working concurrently with either internal or external government affairs, consultants, representatives, to make sure that they have their say sort of in what's going on. And I know Lydia mentioned earlier in Maryland how there is the procurement official and then there's a separate body. We see that in a lot of jurisdictions. DC also requires, for example, the DC Council to approve contracts. So there's inherently, the way that system is set up sort of sets it up that you need a government affairs, you need someone who's tracking the legislation, who's aware of the issues, to be in your corner, lobbying that if that contract gets awarded to your competitor, who is going to object to that? Who is going to raise issues? Who's going to delay the transition, right? So it's super important in the state context to make sure that you have an understanding of, who are the power players, who cares about this contract, not only at the agency level, but then at the legislative level as well, or the ethics board or whatever the third party reviewer organization is in that particular jurisdiction. And that is, to me, one of the biggest differences that we see from dealing with federal contracts, which of course certainly do at times carry a political component, but for the most part seem to be somewhat above the fray in that process. And if I were to offer just one piece of advice on the agency side, is to, that as council, we're looking for errors that you made when we're looking for reasons to protest, right? And having that sort of third invisible hand of a legislator or a agency official that isn't really involved in the process is really low-hanging fruit for us, right? When we hear, that, or we see news reports of the involvement of third parties that really weren't supposed to be a part of that process, you're making it a little too easy for us to go after you on that basis. So you can avoid bid protest by, attempting as much as it's possible to avoid that, the involvement of third parties by sticking to the evaluation criteria, by awarding on the merits of the proposal, leaving politics at the door when it comes to that process. But in my experience, we just see that in every single procurement when it's at the state and local level or close to it. So, I may be preaching to the choir on that. I saw there was a question in the chat. Let me just pause for a second. Oh, okay. There's a comment from Professor Eakins. I will just leave that there. Okay, and then, so another issue I wanted to talk about was the implications of bidding on one or more regions in a state. And we see this, for example, in Pennsylvania at times, or other jurisdictions, they will break up a procurement when it's a large state and there's going to be various awardees. They may break up and this happens in the federal context too, but they may break up an award into, a Northeast region, a Southeast region, et cetera. And offerors will then decide, am I going to compete for all regions? Am I going to compete for one or more? And so one issue that I think we see as causing problems on the protest side is when an offeror wins regions 1, 2, and 3 and loses regions 4 and 5, and then has to make that political decision about whether or not to rock the boat to protest their exclusion from the first few sub jurisdictions, the regions, and then risk rocking the boat. I thought it was really interesting, Bill Curry's comment in response to Chris's, Professor Eukin's question just before the break about whether or not procurement officials really do find it offensive when offerors protest, because that is a conversation we have with our clients every single time that they decide to protest. More typically at the pre-award stage, we're worried about that. There's more to lose at that stage, but it just sort of hammers home for me the importance of knowing the politics, knowing your contracting officers, knowing who the other bidders are, and just the implications that how that's going to look like after the fact if you protest. It is a political decision. It's a business decision at various points to make that decision whether or not to protest at the pre-award stage, at the post-award stage. But it's even more complicated when in the state level context where you have awards that maybe you may have a partial award in one region and not in the other. So those are just some of the issues that we face, things to think about, both from the agency side and the bidder side slide. I have a few more points on the next slide, and then I will turn it over to Bob. Okay, so as we're thinking about procurement reform and the model procurement code, there are things that I have noticed that I'm hoping can be changed in the system as we progress as a community in terms of issues that we see in state level procurements that do lead to protests, and that not only lead to protests, but that make protests less successful or more of a challenge when we go through that process. So at the federal level, we have a very fulsome body of case law, but I've noticed that in the state and local levels, it's not even close. Some jurisdictions like DC, for example, Maryland, I believe as well, do have maybe just simply due to their proximity to Washington, but do seem to have a more fulsome body of precedent that makes it very helpful for us to have an understanding of how your agency, how your state is going to look at this issue going forward. Otherwise, we are sort of shooting in the dark, and it really doesn't help your contractors going forward if they don't have an understanding of how are you going to look at this issue? How are you going to consider? For example, if an RFP says it's up to the agency whether or not we can conduct discussions. At the GAO level, at the Court of Federal Claims level, we know exactly what that means, right? We know if they open offerors discussions, one offeror, they have to open them with everybody, and that has been litigated to the nines. But in states where that's not as clearly set forth, it makes it harder to have a fair process throughout because it's not clearly set forth. Do they have to conduct discussions? And if they do it, can they do it with one? Can they have to do it with all? Can they limit it to the competitive range? What does that look like going forward? Because the precedent isn't there. The regulations aren't there, and then the precedent isn't there. And that makes it harder for us to know what was fair under your state's jurisdiction, and then how we should move forward as litigants after the fact when we learn, for example, the agency conducted discussions with the awardee and not with everybody else. So that lack of useful precedent is harmful to the integrity of the process. It's harmful to contractors. And so that's something that we would love to see more of, is more published decisions, more guidance from the agency. Sometimes states have procurement manuals that are decades old and have never been updated, right? And we're just looking to that to try to find out what are your rules, how do you do this? And it's to me, it challenges the integrity of the system. And so that's just one area we'd like to see. Moving on next, the other issue that we see that we would love to see reform is our consistent requirements from agency reports. As I think it's been talked about a lot last night, but I think everywhere that obviously the rules are going to vary state to state, but as we're amending the model procurement code, encouraging jurisdictions to open up their process by allowing access to the agency report. Clearly, we understand why agencies would have a incentive to reduce the amount of documents, the amount of scrutiny that's raised by looking at their agency report. But it does, again, in my opinion, harm the integrity of the procurement system. That as I said, it may not be a way to reduce bid protests, but it certainly is a way to make bid protests more effective for everybody involved. If we're all operating with the same information and can have the opportunity to challenge that. It also would reduce the administrative burden on the agency side because, as I'm sure many of you are familiar, often in states where there's not an automatic right to view the full agency report, we're often fighting both the protest and the FOIA request at the same time. And so we're litigating sometimes several FOIA requests at the same time, plus protests, plus supplemental protests based on a drip drab of documents that come in one at a time based on various court orders. It really draws out, it's more expensive for litigants, more expensive for the state. It's not efficient. And it really just complicates the whole process. Whereas the federal level, that's not even really an issue. Certainly we'll have fights about, a couple documents here and there in the report, but in general, it's understood that the evaluation documents are produced. So those are my ideas and thoughts on issues that we see, ways that we can improve our systems, both in the US and certainly in other jurisdictions too. And I'm happy to answer any questions. If not, I'll turn it over to Bob.
Thanks very much, Liz. I don't know if you saw the comment, but you got a very laudatory comment that suddenly from an former Air Force contracting officer, suddenly you can understand what the wizard is thinking behind the curtain. So thank you.
Okay, so the filing fee. So the GAO actually did implement a filing fee. I haven't seen any statistics on whether or not that reduced the number of protests. But when you're dealing with protests, I mean, at minimum hundreds of, no one's going to protest for a $10,000 contract. We're talking about at minimum hundreds of thousands of dollars, sometimes millions, tens of millions, $billion-dollar contracts. A $300 filing fee is probably not gonna really limit anybody. The only one maybe it would limit would be a one-off, really tiny company that is doing it on a pro se basis. But if you're hiring counsel and you're gonna have to pay a $300 filing fee, that's sort of a drop in the bucket. So I guess the short answer is probably not.
The Brits.
It does not factor. I've never heard it factor into anyone's decision.
Dan Cheney talked a little bit on Tuesday about how rare it is to, it was Zach Jacobson was actually based on his paper, how rare it is to have a bonding requirement. The Brits have a very heavy bonding requirement, and there was a very strong move in the European Commission before Brexit to challenge the Brits bonding requirement because the European Commission felt that it created a non-effective bid protest system. And almost everybody around the world has committed through the Convention Against Corruption to have an effective bid protest system. So to answer Zach's point, high bond requirement creates what would be considered a non-effective protest system because it's difficult for people to access the system.
Let me jump in for a quick second. Have you mentioned the California Alternative Procurement or Alternative Protest Project?
No, we haven't, Bob.
If you haven't, it does have a bond requirement. When you submit a proposal that is subject to this alternative process, there's someone called a bid protest coordinator who may not be a lawyer, who makes an initial determination of whether your protest is frivolous or not. And if the coordinator determines that a protest is frivolous, then you have to post a bond of up to, either you have to withdraw the protest, easy enough, or you have to post a bond of up to, a bond of not less than 10% of the estimated contract value. And I have actually had situations where clients wish they had good grounds for a protest, where we have filed a protest pushing some of the limits of the law or the facts as we knew them. And in one of these, we did get that frivolous determination, and I think it would have cost something like $10 million to post that bond. And if you post the bond and then the protest is later found to be frivolous in the Office of Administrative Hearings, you forfeit that bond. And there are very few companies who want to take that kind of risk.
Bob, if we could just introduce you briefly, we have a hard stop at 8 o'clock Eastern time. So what I'm going to do is I'll follow up with the participants who've signed up for the bid protest. I'll follow up with them by email. I'll be setting up a meeting with them on Friday and on Monday. We'll be having communication so that they can prepare for the bid protest, the mock bid protest next week. Bob Metzger joins us. He's the head of the DC office of Rogers Joseph O'Donnell. He has handled a large number of very, very significant bid protests, including recently the Jedi protest at the federal level. He also was a co-author on the August 2018 report, Deliver Uncompromised, which was really a cutting edge report on how the federal government might approach issues of cybersecurity in contracting. He was a graduate of Georgetown Law. He's a BA from Middlebury College. He's also a recognized expert on state procurement issues, including especially IT issues. Because we have a hard stop, and I apologize for that, because we have a hard stop, we're not going to be able to get through all of Bob's slides. But Bob, can I turn it over to you, and I'll
Yeah,
make
let's do it. So, I've been doing state and local procurement for a longer time than I might be willing to admit. And the first thing to recognize is that it's different everywhere. Now, there are certain, well, in the federal system, there's the FAR, the DFARS, or an agency supplement. And that gives you a pretty good idea of what you're going to be looking at that will govern the procurement and the protest. And there's the GAO that has this body of precedent. And there's the Court of Federal Claims that has its own body of precedent. And you kind of enter into the field of a protest with a fair amount of knowledge of what the agency is supposed to do, the laws that it is supposed to follow, and then how the GAO or a court is likely to view the arguments you made. Moreover, because there have been so many protests filed as to so many federal actions, a lot of these doctrines are pretty well practiced, and many firms have core arguments already built. The states are different. Every state is different. And sometimes the procedures can be different even among agencies and department within a particular state. And so I have a slide later, I think I can summarize it now, which says that when you come to a new state, you want to kind of go from the top down, sort of start at the Constitution and see what it says. You might say, well, why would a Constitution affect a bid protest? Well, if your bid protest is complaining about limitation of liability and the state constitution forbids the state from assuming certain types of liability, you probably ought to be aware of that. And you certainly want to go through statutes. You want to go through the administrative regulations, the contracting manuals and regulations, constitution, statutes, regulations, policies, practices, and then to the extent you can find out kind of, the local lore and who knows what that isn't written down. Obviously, there are some common principles in protest. Inevitably, the protester, thinks that it was improperly evaluated under the criteria that were specified, and that's allowed in many places. Sometimes a state may say that I'm not going to let you challenge the evaluation. I'm only going to allow you to bring a protest if you can show a law that I violated. And so you kind of have to hit the reset button to find the appropriate context every time you get there. And the extent to which you get information can vary a lot, as we've heard earlier. Sometimes you'll find it is fiendishly difficult to get even the beginning of information. Other times, such as in California, if you go through this alternative process and get to the Office of Administrative Hearings, you're going to get a fair amount of information. One of the challenges for protesters inevitably is that you, especially in states where you have a very short period of time between award and the due date for protest, is getting enough information to make an informed decision of whether to protest at all. And rarely, although I have many times resorted to Public Records Act or Freedom of Information Act filings as a way to get information relative to a procurement, I would say it's an exceptional circumstance when I get that information quickly enough to inform a protest decision. Now, obviously, having been the lead counsel for JEDI and then also lead counsel for Microsoft at GAO in a $10 billion NSA procurement, I have a pretty good idea of what can take you to protest and what motivates companies to do it. I also have written a law review on the article on the subject a few years ago. I'm not actually a giant fan of protests. If they're not managed properly, if there aren't appropriate boundaries, they can become simply an opportunity for gamesmanship, entrepreneurial maneuver, and they can do a lot of disruption to and delay important public purposes. And so what I've seen in a number of states, including California, are efforts to try to limit or constrain the bid protest system so that it is still fair, but difficult and often fast. And this alternative protest process in California is it's a pretty good example of something to look at that hardly encourages you to protest, but lets you do so and have at least a reasonably well articulated process if you do. So let's look at this first slide, forces and factors at work. There's a whole lot of complications in every state, at every locality, a lot of vectors kind of moving in different directions all at once. You know, needs generally tend to grow, but the nature of the solutions to satisfy those needs may change. The amount of money available may vary. Sometimes states will want you to pay for a particular program out of the proceeds that you save or gain. Knowledge is always a problem because typically, especially in larger IT contracts, those who are selling have a great deal of knowledge about their products and solutions and quite a bit of knowledge about local procurement rules. Sometimes they can almost overwhelm, the state officials who just don't have as many people and don't really understand as much about what is being proposed. And so in that situation, we see a market emerging where when they can afford it, state and local governments will hire specialists to help them to equalize the knowledge balance. One of the biggest problems that confronts state and local procurements now is the rate of new technologies. When I prepared this slide, cloud was a new thing. Well, cloud is much less new now. But what we have now that is different is suddenly state and local governments have realized that they're at risk of ransomware attacks or acts by other cyber criminals who may seek to breach their system and steal their information. And when you combine new types of threats, new vulnerabilities, uncertain impacts, potentially uninsurable consequences, this puts a fair amount of pressure on the state. And often where you see that pressure express itself is in demands to the contractor that they relieve the state of any and all conceivable risks or exposure that might follow from these new hazards and new vulnerabilities. And that can create a problem because one trend we've definitely seen is that increasingly states are buying solutions, not so much the services. And if they were buying services a little while ago, that's different from buying physical assets. 15, 20 years ago, the big thing was to offer, say, a new payroll system. And you would take the legacy system and replace it and build on the premises of the state something completely new using a so-called waterfall process. And the state would be spending a huge amount of money to get what would be a custom prepared solution for its unique utilization. Well, I defended SAP in such a program where it wasn't satisfactory to the state, and we had very large litigation. One of the byproducts of a bad acquisition is likely to be a failed project and litigation that follows. That's not good. What we see now is an increasing intention of states to be essentially buying things that are cloud-based, where the solutions that they want are off the shelf. They're commercial products that are then customized for the benefit of the state. And we also see their replacement of this highly elaborate, staged waterfall method of procurement with agile methods. And in an agile method, you may have a process where the state says, here's my 10 big goals, and here are my 100 objectives. All you have to really commit to is the 10 goals. And instead of having, 1,000 steps of individual performance actions, each reviewed and approved before you get to a final go live and system assessment, you can have a series of, sprints where somebody decides that you're just good enough to go to the next sprint. Well, all of these eventually kind of move towards a point of conclusion. And at that conclusion, the state has to decide whether it's going to accept the version of the system that you delivered or whether it demands something different. And at that setting, you can have some real problems if the contractor's assumptions are different than the ones of the state. If the contractor's assessment of whether it met the goals are different from what the state requires. And this can produce some nightmarishly complex disputes. And I've been living with one involving, how can I say this correctly, involving approximately a 9-figure problem on a big state's management of certain type of benefit. where there, what we thought was a very well-developed process to go through development of deliverables and their acceptance en route to final acceptance, eventually showed a gigantic disconnect between what the contractor thought was expected and what the state demanded. Well, as bigger companies look at new state procurements, no matter how big the dollar value might be, they're going to assess the extent to which they can both understand the risk and manage it. And if they find that the risk is too large because of uncertainties in the requirements, they're going to hope to have a chance to negotiate. If they find that the risk is too large but not negotiable, they might choose not to bid. They're going to look extremely carefully at the selection criteria and the process. Sometimes it can cost millions of dollars to prepare a proposal. And when companies put that much time and effort out, when they make proposals that might call upon them to assume a substantial amount of risk, they have a great interest, understandably, in knowing that the process of award is fair. And they also have a great interest in making sure that there is good governance and management on the state side. Because if there isn't, you can have situations, and I've been in these disputes too, where there's literally disagreements among various state agencies and departments as to what they want. A single provider of a solution, 25 agencies and departments, none of whom actually agree without any clear guidance or governance as to who's going to decide which. So companies take a pretty careful view of when to bid and what risks to assume. Now I'm jumping around here. Let's go to acquisition processes Q&A. I've said, next slide, please. I've said many times over many years, and I've written various white papers on the subject, that the use of competitive negotiations is very important. We can think of the acquisition process as just a question and an answer. An RFP with its statement of requirements or objectives is the question from the state, this is what I want. And the proposal of the contractor is its answer. And then the evaluation is to determine how well the answer matches the questions. Well, if you think about some of the more complex undertakings now that may cut across multiple state agencies, which are seeking to consolidate data to move services to automated bases, which are looking to enable citizens to access state functions using edge devices like a tablet or an iPhone. If you're thinking about ways to automate the work of the state workforce, to both protect and secure data and make it available across departments and agencies and for multiple functions, well, that stuff gets pretty complicated in terms of the objectives, and the methods that are going to be employed to meet those objectives can get very complicated, and they can be very different among offerors. And this is where excess rigidity in the system is going to create many major problems. It's essential, I think, that states that are seeking to modernize their functions to transform from legacy to data-driven functionality, they need to have the opportunity to negotiate with their vendors before they make an award decision. I've seen situations where very complex requirements are put into an RFP and where terms and conditions are put out that are just unacceptable, some because they depart from commercial norms, some because they would harvest the contractor's previously developed IP. And in situations like that, I've advised, leading companies, tier 1 companies, as much as they think they can do it and want the work, to no bid. And I've also been in situations where I've advised companies that the risk may be tolerable, but only if the company after award takes a very aggressive approach towards performance, so that it's looking for any and every opportunity to gain leverage, small, medium, or large, during the course of performance. These things have to be done intelligently, and they have to be done with a sense of fairness. And in these complex situations with new solutions and uncertain technologies. There's often a tendency on the part of state contracting officials to look at the terms and conditions. Let's go down a couple more slides. One more. Next. Okay. There could be a tendency on the part of state officials to think that they're doing a great job by thinking of every conceivable risk that they understand and those that they imagine but don't understand, and to write terms and conditions that appear to shift the risk to the contractor. I've seen this, 1 million times on 1,000 different terms. Well, that's actually not such a great idea. First, to the extent that we're buying derivations of commercial solutions or buying things that are delivered off the cloud, you cannot have the sort of custom unique to state X of something that's being sold to 20 states and 1,000 other customers. You can get some customization, but you can't have it done your way specifically. And if you shift too much of the contractual risk to the contractor, if you're unyielding in your unwillingness to accommodate its commercial practices, terms and conditions, some of the best contractors will not bid. And I've seen that very many times. And you can get into a situation where you can have protests, because I've been in this situation too. And I not long ago was in a situation where one of my clients in a procurement I obviously won't identify looked at the requirements for a system and said, gee, this buyer, a public entity, really doesn't understand this technology. And we are going to send them a letter that accompanies our proposal, which says in 5 pages, 25 or maybe it was 50 enumerated items of where this particular public buyer obviously didn't understand what it was asking for, and ought to redo the solicitation to conform to my client's expectations. I did not advise them to do this. I got into this problem after they said, what do you think happened? I mean, this is the classic, we know better than you state. And I think in this case, the state was wrong in many respects. But, if you decide that you're going to tell a public buyer in chapter and verse all the things that are wrong in their solicitation, and if the public buyer isn't able or willing to negotiate the solicitation or the terms of the final contract, you're going to end up being disqualified, which is what happened. And the particular client said, this is an outrage. Everybody knows that it can't be done the way this buyer wants. The other guys who were selected, they know this too, and they were just willing to say that they would do it, even though they know they can't. And I said, let's not protest this. This one you can't do, because the surmise that somebody else won't do it any better than you or suffers the same problem that you had is not going to make you compliant with the solicitation terms. Now, terms, when we're focusing upon the award process, our key interest is in making sure that we conform to the solicitation requirements. You have to pay very strict attention to what you're told to do or not, as I think Lydia and others have said. Where in doubt, don't vary. You also want to be looking pretty carefully at those terms and conditions, even if that seems kind of after the fact. Sometimes people say, well, I just want to get the contract and I'll worry about the terms and conditions later. But especially as performance gets more difficult, the stakes are higher, the risks are greater. It is really important not only to know what the terms and conditions are, but to be sure that you can live with them or manage the risk, or that you have an opportunity to negotiate those terms and conditions. Because those terms and conditions, which include the statement of work, the specifications, deliverables and milestones, terms and conditions, when things start to go wrong, you're going to pay a huge amount of attention to all that stuff, because those are the things that are going to govern whether you have a basis of dispute, a basis for a claim for equitable adjustment, or a defense determination if things really go terribly. So there's a lot that's really demanded of lawyers, both in creating the requirements and designing an acquisition process. A lot of care that's needed to conduct a procurement, a lot of attention to detail that's required by the lawyers in-house or otherwise, all things being equal, you want to submit a proposal with a low risk of being discrepant, where you're confident that you satisfy the requirements such that you would be able to resist any claim by a disappointed offeror that you fail to satisfy them, and where you've done a careful risk analysis to consider, what are the risks of performance? What opportunity do you have to control or manage those risks? How can you mitigate them? And, are the demands of the state something that you can do without affecting adversely your enterprise value? I had another recent state contract where in a state which ordinarily looks only for license rights and doesn't demand ownership, the state seemed to take the position that any modification that you make to your commercial program is ours. Well, I mean, that kind of sounds reasonable, but in the nature of solutions that are sold to many states or other public sector entities, you learn from every experience you get. Can't have a situation where you're essentially communicating your intellectual property to the 31st buyer because you made some changes to improve upon what you did for the 30th. So I've covered not enough ground, but I hope I've made some interesting comments for you. I don't believe protests should ever be made purely for the sake of harassment or to challenge the integrity of officials. But extreme facts can happen. There can be situations where objectively, and I've been in these things too, where there was mention made earlier of local officials. I did one in, I think, a county of Los Angeles, a big IT procurement, and the result was really inexplicable. You just couldn't make any sense of it. And even though it was kind of a tough road a few years ago, we chose to make the protest and to involve a lobbyist and to try to investigate just how the outcome occurred. And eventually, I think it was superseded. It's all different. Everything changes. Perspective differs for the nature of the procurement, and lawyers have a valuable role to play in making sure that your bid is good and in giving sound counsel in the event that you win or you lose.
Thank you so much. And I want to respect our hard stop. I really want to thank our other panelists, Bill, Lydia, Liz. Thank you so much for your contributions. This should be on the recording of this program should be online by early tomorrow. And we're going to have our next session on Tuesday between 6 and 8 p.m. At this, again, accessible through the same channels. So again, thank you all very much and have a very good evening. Take care. Bye-bye.
Thank you.